Hello, my name is Jonathan Edwards. I'm a barrister in private practice at Radcliffe Chambers. One of the areas I specialise in is wills and estates. I'm going to be delivering this short webinar to you today on that subject, and specifically the issue about practical tips for how you can avoid, as a practitioner, claims against the estate. And we're thinking here about steps that can be taken in advance. So in particular, during the will-making process, around that time, to try and insulate the estate from claims after the client has died. So to begin with, I think it's worth just bearing in mind why there does seem to be so much of this litigation these days. I think there are a number of reasons why you could speculate that there are more of these claims than there perhaps were. Probably the most powerful factor, I suspect, is that inheritance is much more significant for many more people these days than it was historically. I think that's mainly because of house price inflation, the right to buy, and developments like that, meaning that many estates are more valuable, more worth litigating over than they would have been historically. And many more people count on inheritance in a way that perhaps they wouldn't have done in previous generations. A second factor that I think encourages litigation is that another change in society has been the ageing population, which brings with it, of course, a greater preponderance of dementia-type illnesses and a better awareness of those kind of illnesses and the effects they can have. So I think that both means there are more wills made which are perhaps open to attack, and even if they're not open to attack on the facts of the case, there are people more aware that it's a possible argument that they might want to explore. The third factor is that I think compared to previous generations, there is a greater number of more complicated family arrangements. So practitioners in this area will be very familiar with the kind of dynamic that happens where two individuals who already have children from previous relationships remarry or start cohabiting together. And so they each bring their own families with them to the relationship. And although those two people might be committed to each other, they might have different views about who should inherit what on the death of the survivor. So it's very common to see a grievance where one partner's estate is left to the other partner, and then that surviving partner leaves everything to their children and leaves either a lot less or nothing to the children of the first partner to die. That's just one example, although it's an example that comes up a great deal in practice.